Flaster Greenberg presents New Jersey's Site Remediation Reform Act, a practical approach. This program was recorded November 18, 2009 at Flaster Greenberg's Conference Center in Cherry Hill, New Jersey. In this segment, Traps for the Unwary with Marty Judge, a shareholder in Flaster Greenberg.
I want to talk about now some what I call traps for the unwary. A lot of this has been alluded to before, and I think many of you have been to seminars like this before and have heard some of these themes before. So I will try to gloss over that which you've probably already thought about and try to focus in on some of the things that you may have not thought about. Under the statute, the covenant not to sue remains in effect as long as the REO conditions are satisfied. So what happens when they're not satisfied? It's kind of a slippery slope. You could have a situation way off in the future where DEP might be pursuing you. The second bullet here is really key. How will third parties treat the issuance of an REO? Right now there's this whole infrastructure where banks and lenders and insurance carriers and purchasers look at an NFA and they say, that's great, that's a seal of approval. DEP has looked at this remediation and they've got this document. It's almost like a marriage license. It's a certificate that says something. Now you're going to have an REO issued by an LSRP. I think there's going to be a shakeout period. You're going to have a period of time when lenders are going to maybe be a little bit more circumspect about lending on the property. It's not so much a question of a lender fearing that the lender will have lender liability. Those of you who have been around long enough remember about a decade ago all the lenders were afraid about their own liability. That's not the issue. It's about the collateral. Is it clean? How do I trust this LSRP? It's a big issue. Nobody's mentioned this, I think, before, but the REO does not provide protection against natural resource damages. So you've got a groundwater contamination issue. DEP could still chase you. Also, when the statute was amended, it extended the deadline, the statute of limitations for the DEP to pursue natural resource damage claims. This is probably about the fourth or fifth extension. I think this is the final one, but it means that there will be a period of time off into the future, even after issuance of an REO, when you could still be exposed to being sued for natural resource damage. DEP has been, I mentioned earlier, been adopting and is continuing to adopt these technical guidelines, and they are doing this generally without public comment. And they adopted several of them on November 4, and one of the speakers mentioned that they're going to come out with revised guidelines soon on vapor intrusion, for example, and there will be more. Bottom line here is these are just guidelines. They're not the same thing as the tech regs. They're written guidelines, but they're changing and they're evolving. And so a lot of little traps here. You could have a situation where your LSRP acts in good faith on a set of guidelines that was in place on one date, and then 6 months later, DEP changes them. What happens? The tech regs have a certain permanency to them. It's difficult for the DEP to amend its regulations, not so difficult to amend guidelines. Another issue is, and this is more of a legal question, the guidelines have not been adopted in strict conformity with the New Jersey Administrative Procedures Act, which is the law that regulates how DEP enacts regulations, and that has provisions in it that call for a period of time for public comment, and then they're supposed to address the public comment, and they're not doing that. It raises a big red flag in my mind, frankly, about whether the guidelines, if somebody were to litigate, are even going to be able to hold up. Are they constitutional? And the statute says they can issue the guidelines, but the reason the Administrative Procedures Act was enacted was in response to court cases decades ago that said that there's a due process standard and the public has a right to participate. The public's not participating in these. Guidances between jurisdictions can differ. That's the part of the hierarchy I referred to earlier, where you may have different there isn't any guideline, so the LSRP looks to another state. What if the LSRP looks to Delaware and it says you can leave this stuff alone, it's not harmful, but Pennsylvania says, no, you got to take it out, it is. How does that get resolved? I don't know. And that kind of gets into the next issue, which is absent a clear standard, reasonable minds may differ about what is protective of human health and the environment. A lot of judgment calls here, a lot more so than sending paperwork to the DEP, bickering with a case manager, and then just not liking it, but at least getting a definitive decision. Some issues with regard to the new site remediation permits. Generally, because DEP is going to be issuing permits, there's still that level of state jurisdiction and control over your project and your cleanup even after the RIO is issued. Nobody's seen a permit issued yet, as far as I know. In fact, I'm not even sure, maybe others can tell me if they've even posted, they haven't. They haven't posted, on the website yet, what the permits are going to look like. Who knows what they're going to say? Fees and financial assurances could wind up getting expensive. And what I'm talking about here are not only the financial assurance issues, but the LSRP fees could get quite expensive. Some other issues. You may still have more traditional permits that you're still going to deal with, and there's some level of DEP influence and control there. You may have a site that's on a navigable water body, so you have a waterfront development permit you got to get, or a dredging permit from the Army Corps, soil erosion permits from your county, your municipality, fill and elevation approvals from your municipality. This is especially important if you have a situation where you cap. Sometimes you actually have to go to the town to get approval for the elevation change. Big issue for lawyers. Not sure too many people have thought about this, but is the statute itself constitutional? Everybody seems to have forgotten in the hustle and bustle of all this that the environmental groups wrote a white paper to Governor Corzine during the interim period from the enactment of the legislation to his signature, and they basically wrote 7-page legal brief, telling him this is unconstitutional. This is an improper delegation of state authority to the private sector, and there's case law in New Jersey that says you can't do that. What are they going to do? I'll bet you they're going to sue at some point. They may not sue based on, now, based on the, as a direct challenge to the regulations, but if I were they, I would find some appropriate test case and then make that case my vehicle for advancing these arguments. That's really my next bullet point. But anybody could sue. Suppose your neighbor across the street is not happy about the fact that your LSRP has certified that the stuff on your site did not migrate off of your site onto his property, therefore his stuff is his problem, because he's been arguing with you, it's yours. What's your neighbor going to do? Might sue you. Might challenge the RAO. Frank doesn't like me to mention this issue, but I want to mention it real quickly. This is what I call the Alice in Wonderland problem. Basically, the problem is this. There's now, right there in the statute, an affirmative duty. You see this shall remediate language down here? If you're a person in any way responsible for a hazardous substance, meaning under the Spill Act, you now have an affirmative duty in the statute to remediate. Why is this a problem? A couple of decades ago, the Supreme Court dealt with this case called Kimber Petroleum. Back then, the DEP was issuing treble damages Spill Act directives. And they were basically saying, clean up or else. We'll sue you for treble damages. And then people were saying, but I'm not responsible. The DEP was saying, we don't care. Clean it up or else. And people would go take DEP to court, and the DEP would argue, you can't take us to court. There's a ban on pre-enforcement review. We haven't sued you yet, therefore you cannot take us to court. And people were between a rock and a hard place. The New Jersey Supreme Court recognized that and came up with this thing called a good cause defense. And what you can do is when you get a Spill Act directive, you can write to the DEP and say, I don't believe I'm responsible for the following XYZ reasons, therefore I'm not going to comply with your directive. And then if they do sue you for treble damages and you can show that you had at least good cause to believe you were not responsible, you're off the hook for at least the treble damages. You'll still be responsible for the cleanup if you're liable. So the Supreme Court basically bailed out the DEP. Now along comes the legislature and enacts the SRRA, and it basically goes back to the same situation. What do you do? Where do you go? Can you file declaratory judgment action? And if so, will the DEP again argue no right to pre-enforcement review? Where do you go? It's the Alice in Wonderland problem. In the event of a third-party challenge, where would somebody go? Lawyers. This is a lawyer slide. There are 3 possible courts in New Jersey: the appellate court, the law division, or the chancery division. There are 3 possible explanations and theories that lawyers could advance. Nothing is in the statute to explain this. So before there's litigation on the merits, there's going to be, I guarantee you, a lot of cases lawyers arguing which court we belong in. Nobody knows. I don't know. The bottom line is there's a lot of uncertainty here. You've heard this theme before. Some of it's going to get resolved as the program matures, but there are a lot of traps for the unwary, a lot of pitfalls in all of this, and just be aware of it. Thank you.
We hope you enjoyed this program brought to you by Flaster Greenberg. For more information, call 856-661-1900 or visit flastergreenberg.com. This program was produced by Professional Podcasts in Cherry Hill, New Jersey, on the web at professionalpodcasts.com. For Flaster Greenberg, this is Steve Lubetkin. Thank you for joining us, and take good care.